Hi, today we're going to discuss intellectual property law. During this chapter, we'll know the following areas: different types of intellectual property that apply to sport. We'll look at trademarks specifically and see how they're utilized in sport, the industry, and mainly as a way to generate revenue. We'll look at how organizations can protect trademarks, copyrights, and patents. And we'll also look at the revenue creation idea of right to publicity, the values that athletes have in the commercial right of their name and likeness. So we look at the idea in terms of sport. How do we create revenue? We have tangible sources such as merchandise, tickets, and concessions, but also these intangible sources, these licensing opportunities or merchandising opportunities that we can go out there and sell the name and likeness, the events, and the names and logos. So when we talk about merchandise, we can look at in terms of merchandise in terms of the wearables themselves would be tangible. The logo that goes onto that piece of merchandise is intangible. So we create this idea of intellectual property, and it's a property right over artistic and commercial assets, much like we have property rights of an actual thing that exists, a tangible object. We provide rights to commercial and artistic assets. So a person that creates a piece of music or records that music or writes a book, we protect their commercial interests in that they're allowed to sell and create revenue any way that they would wish, and they control that endeavor by themselves. So we're looking at sharing different music or downloading copyrighted material. We really are stealing the idea that this is a way that these people are supposed to make money, and if they're not able to generate revenue from that, like if we download music, if they're not receiving the revenue for that, then there's no incentive to create that type of music again. So we're going to look at trademark, trade dress, copyright, right of publicity, and patents. The protections that we look at would be patent law, copyright law, where we're protecting the invention themselves and the creative works. Whereas trademark laws and unfair competition type laws, we're protecting consumers from deceptive and misleading advertising and their marketing practices. So we're looking at a couple of different ideas and places that the background of these laws and where they're going to protect. A trademark is any word, name, symbol, or device that an organization uses to identify and distinguish its services from the services of another organization and to indicate that source of the service. It's a trademark. It's that word, name, or symbol that distinguishes us from other competitors. It's governed by the Lanham Act, which is the Trademark Act of 1946, that says trademarks and the registration provides causes of action. It provides a place for us to bring a claim against a competitor that's using our trademark or something similar to our trademark to confuse consumers. We're looking at preventing others from using our mark in a way that will cause confusion. We can look at trademark law through dilution. Dilution is the lessening of the capacity of the famous mark to identify and distinguish goods or services. So when a party uses or modifies our mark that weakens the original mark, it's blurring. When the mark is used in association with unwholesome or shoddy goods, it's tarnishment. In other words, if a company would come out with maybe trying to compete in fast food hamburgers, and they were known as Rolls-Royce hamburgers. The Rolls-Royce car manufacturer may have a claim of dilution, at least in blurring, if not tarnishment, because this famous mark that we have for Rolls-Royce is now being associated with very inexpensive hamburgers. It certainly would be trademark infringement if the competitor didn't make hamburgers, if they made go-karts or motorcycles or other automobiles, certainly would have an infringement claim upon that. So the functions of a trademark: we identify the goods and distinguishes them from others. We signal that the goods come from a particular source. We indicate that products are of a certain quality, and we advertise, promote, and assist in selling the particular goods. Even if we've never tried a Rolls-Royce car before, if we've never looked at one, if we've never compared and shopped or even test drove one, never even saw one, we have this idea because of the trademark, because of the advertising that they've built, the brand equity that they have, that we have certain assumptions about the product, one of which is this high quality. Now, if somebody is allowed to use that same type of trademark and try to go after a different type of product without the same, now we're getting this idea that it's going to infringe it, it's going to blur, it's going to tarnish the original mark. When we look at trademarks, we look at classifying them in a few different ways. One, arbitrary, fanciful, suggestive, descriptive, and then generic. An arbitrary mark. An arbitrary mark has a word, name, or symbol that's completely arbitrary. It's the most distinctive. It's given the most amount of protection because there's no connection that we have to the product. For instance, Nabisco. We have no idea what Nabisco is because Nabisco as a word doesn't exist except for the connection that they have to the National Biscuit Company. Reebok, certainly generated from the animal, but it's being applied to a specific area. It's created solely for the athletic gear company. When we know and we can make that assumption, if we make that connection between the trademark, the arbitrary mark to that product, we're going to give it the most protection of all trademarks. Second is fanciful. A fanciful is inherently distinctive because they describe the source of the good, but not actually the good itself. Nike, the Greek goddess of victory. It inherently talks about it, source of the good, victory, running shoes, but it's fanciful. It's not arbitrary because Nike already exists. It's fanciful. It's the second highest amount of protection that we're going to give because it doesn't really talk much about the product, whereas a suggestive mark does, where some creativity to understand the product, but it does describe Hot Pockets. We kind of get an idea. We need to go a little bit further, but when we see what a Hot Pocket is in the name, it makes sense. It suggests what the product is. A descriptive mark isn't very well protected because it talks about the goods or service. Gold's Gym is descriptive. It tells us the product. It's a gymnasium. It's not protected unless it acquires what's known as secondary meaning, that Gold's Gym has so much advertising, so much knowledge base in the industry that it's a specific brand, it's a specific product, which will give it some protection. Otherwise, we're not going to grant it because it describes the product. The last one is generic mark. A generic mark is a trademark that's so common that it doesn't receive federal trademark protection anymore. For example, Jell-O was going that way. And we have a lot of different examples. Kleenex, Xerox, FedEx, Google. Any of these brands that are named either as a verb or as a noun for the entire product category is destined to become generic. Ping pong, putt-putt, frisbee, all are examples of brands that have become so common that they may perhaps be losing their protection, which means when the Wham-O company is selling frisbees, that they call it frisbee. If it becomes generic, then anybody can make a rubber flying disc and call it frisbee. That it loses that protection, it loses that value. We look at different types of trademarks. A collective mark, which is a group. The NFL, the NHL, the NBA is a group or association of different trademarks and that has membership. Also a service mark. A service as opposed to a product can develop a trademark as well. So who owns the trademark? If we have 2 or 3 different companies with similar names, and they're entering a marketplace and they want to protect their name or their product, it's the first into the marketplace has some protection. It's suggested and recommended that they register the mark in the trademark office. However, it's not required. Trademark office does provide notification to everyone that you have a registered mark, thereby giving you much more protection. But as soon as you start using it in the marketplace, you have some sort of protection for that trademark. And we'll look at a number of different cases that talk about different trademark and the ability to use trademarks in the marketplace. Some of these are from individual places like Crazy Legs Hirsch. So when somebody uses unauthorized use of a trademark, a competitor perhaps, that's likely to cause consumers to be confused or deceived about who owns the trademark, it's called trademark infringement. If you ever saw the Eddie Murphy movie Coming to America, there's a big scene in there, and certainly you can YouTube and discuss this, about the hamburger place that they were working, McDowell's. And they talk about how McDowell's and McDonald's are very similar. One uses the golden arches, one uses the golden arc, and they have the Big Mac and the Big Mick. That's trademark infringement. Trademark infringement is a second company calling its product something very similar so that consumers buy their product by mistake. We can look at this in sport in terms of merchandise, in terms of equipment, even in terms of leagues over marketing of sport. We want to make sure that we develop our football league, our hockey league, our field hockey league, our volleyball association, whatever it would be, to be distinctive so that consumers will purchase our product, consume our product, and not a competitor thinking that they're really buying the original. In order to prevail on this claim, the trademark owner must show that they've used and they've hopefully registered the mark, and they must demonstrate that the other party's use of the mark is likely to cause confusion or deceive consumers about who the true source of the trademark is. We need to show the court that people are likely to purchase the other product thinking that they're really buying mine. When we look at the different factors, the Polaroid test for infringement, we look at the strength of the mark. Is it arbitrary or is it generic? An arbitrary mark we're going to give the most protection to. A suggestive mark, not as much. How similar are they? Do we have evidence of actual confusion? Can we show that this amount of people, this revenue generated went to one company and not the original company? We'll look at consumer sophistication in this marketplace. We'll look at the quality of the products. We'll look at the similarity of the products that they're developed and how they're sold and distribution points. Are they the same product? We look at Delta Airlines and Delta Faucets. They're very different products. So the likelihood of infringement is very, not that common. And they've been in existence for a long time, so they've developed them on their own. If the products aren't similar, it may not suggest that there's trademark infringement. We'll look at different types of things that we can protect. In LSU versus Smack Apparel, can we protect colors? Can we protect sounds or smells in terms of trademark connections to different groups? We have some defenses to the trademark infringement. One is fair use. We can use someone else's trademark if it's comparative advertising or if we're in the news or using in media or a parody. We can look at non-commercial use or an artistic transformation. Andy Warhol with his classic Campbell Soups paintings. We can say that the trademark has become generic, that it's representative of an entire product category, not this brand, that the original brand abandoned that trademark, that they haven't made this product, or perhaps we look at it when teams move locations. The Los Angeles Rams left Los Angeles and went to St. Louis. Do they still own the Los Angeles Rams trademark, or has it become abandoned? In other words, could any company come in and make Los Angeles Rams shirts and not have to pay the owners of the St. Louis Rams for the right to use that trademark? And also functionality. Is it something that doesn't describe the product, but it's necessary for that product to actually exist? We look at one Indianapolis case, Indianapolis Colts case where Baltimore Colts left. Did they abandon that name? We look at this idea, why it's so popular and why it's so important in sport right now, is for licensing. A license is a right granted by an owner, known as a licensor, to a third party, the licensee, which permits the licensee to associate his or her goods, services, or businesses with the logos, names, and mascots of the licensor. So the licensor can grant use of a mascot to a licensee who makes jerseys, and the person who makes the jerseys can put the mascot on there and sell jerseys. Granting the license create a contractual relationship between the licensor and the licensee. So we have in sport professional leagues, NCAA teams, colleges, everybody licenses their marks to create revenue streams. Players register and license their names and likenesses in order to generate revenue. We look at the Olympics and how their marks are extremely popular and how they're granted specific protection in the United States under federal law. They don't have to prove likelihood of confusion, just improper use is enough. So we look at different areas. The IOC and the individual Olympic Games use trademarks to generate revenue. We look at nicknames, and trademark protection can be denied if the mark is shown to be immoral, deceptive, scandalous, or disparaging. We've seen that going on with the Washington Redskins, that the trademark office may not protect the Redskins. So that would mean that anyone could create shirts and hats and call it the Washington Redskins, and the Redskins would not get that kind of revenue. Look at Kareem Abdul-Jabbar brought a case against General Motors that we'll talk about. Right of publicity is this idea of the right of any person to control the commercial use of their identity. It's common law, or is created in the state statutes. It's not protected under federal law. The idea that the individual player or celebrity has built up their name and an association, they have created the commercial use of that so that companies can't just trade in on. Michael Jordan using Jordan sneakers. I can't just create a sneaker and put Michael Jordan's signature on it, because that would convey to consumers that he endorses this product, and people may buy it thinking that he endorses it when in fact he did not. And we'll look at Jordan versus Jewel Foods, a case that came out last year that's talking at what point can organizations and companies associate themselves with athletes without paying for their right of publicity. And then we look at an importing case with Rydell versus United States, where Rydell is bringing in a business aspect in order to lower taxes and lower a tariff, not really connected to intellectual property specifically, but certainly increases this idea of sport business to a point that a discussion on this case would make a very good aspect right in this section.